Officer Brett White. He's with the Foothills Area Command. And if you want to give us a little background.
I'm Brett White. I'm the day shift lieutenant for the Foothills Area Command. I've got 21 years on the department. I did field services in pretty much area command except the Valley. I only trained in the Valley. TWI unit for a while, but I was a promoted to sergeant, and now lieutenant in the Foothills. In addition to that, I've been involved in the field training officer program for 14 of my 21 years on the department. So what I was asked to do here today, in the Foothills Area Command, we've been going over the use of force policy with the CPC there every month since December, taking a little piece of it at a time. And I was asked to present last week's to you, so basically we're going to cover 3 paragraphs of the entire policy, not the entire policy, because that would literally take, by my calculations, just to finish in the Foothills, it's going to take me most of the year. It is a long policy, but we're going to cover what's important about it and what's the foundation of the policy, which is right at the beginning, and then everything after this all builds on what I'm going to tell you today. So if we can get you to understand these first 3 paragraphs of the policy, then hopefully as you go through more of it, you'll see how the policy built out based on this information. So hopefully everybody's got the handout with the slides and the little notes so you can see
If you
what's
need
on
one,
there.
let me know.
And as we get to parts of it, I'm going to give you a little bit of background on the law that developed this also so you can understand.
Send the handout down here.
I can pass it out. There's one in front of you.
Okay, I'm sorry.
Okay, so the first paragraph of the policy, this is after all the definitions and after the opening statement. This information comes from a case law called Grant v. Connor. I'll get into that in a little bit. But the first thing you have to understand, what the U.S. Supreme Court said in Grant v. Connor, this is the very first paragraph of our use of force policy. And it says that policing at times requires the exercise and control of a violent or resisting subject to make an arrest or protect the officer, other officers, or members of the community from risk of imminent harm. The reason that's important is because we have to acknowledge and understand that at times force must be used in the job of being a police officer. It comes with arresting some people. There are times when force has to be used. The Supreme Court, when they made the decision and they wrote Grant v. Connor, this is almost a direct quote from it. It's not the actual quote, but it's pretty close to the direct quote of what the Chief Justice said, was that you have to acknowledge that at times force will be used. That's part of the job. The second paragraph talks about that not every violent encounter can be de-escalated, but officers can control some of the outcome based on the decisions they make and the tactics they use. So what this case said, and what we start our policy off presenting is, we acknowledge that force will be used at times. That there are times when force it's going to happen. But maybe we can avoid some of that by the proper use of de-escalation techniques and by the training that we implement. If we can do that, maybe we can reduce the amount of times we have to use force to a level that is acceptable or understandable. Now, I admit that not everybody's going to accept sometimes the force that's used. I get that. And I will tell you right now, as a disclaimer to all this, I do not discuss cases. In this class, I don't talk about what anyone out in the department has done in the field. We're not going to get into what ifs about it because without knowing all the details of the case from beginning to end, I can't tell you whether the case was good or bad. You have to look at the entire case. I can talk to you about Grant v. Connor because I can tell you what the courts ruled out of that case, but I can't tell you what the officer's mindset was when that case happened. I haven't read that entire investigation, and it's huge. So this is about the background about how force is analyzed and how force is reviewed by police departments, by lawyers, by courts when it goes that far in court. If you understand Grant v. Connor, you may not agree with the force used, but hopefully you'll understand how it's analyzed. We will always disagree on some cases. I'm sure we all have cases that we will disagree on the outcome of it. That's why courts get involved. That's why I'm not a judge. If I was a judge, I would be teaching a different class. Those are the guys that decide at the end whether or not the force was justified or not in a criminal situation. But what we're going to try to do through our training is we need to consider when and where to use the appropriate de-escalation techniques. As we're approaching a case, and the indications are usually on call, you can look at it and say, either you know the guy, you may know some information about the person, or the situation itself. If you're dispatched to a domestic violence call, and it says on the call that it's a violent situation ongoing right now, that tells you that there's a chance force is going to be used in this case. So what can we do on the way there? What can we do when we get there to potentially bring that chance of force being used down or eliminate it completely? That's the goal. Part of the way we do that, and this again is all part of paragraph 2, is while you're going through the case, and regardless of what's going on, you have to continually have part of your mind assessing what's happening, what's going on that will increase our ability to bring this situation to a safe conclusion or a peaceful conclusion. This is a constant process. It doesn't stop once we walk through the door or once we arrive on scene and we say, okay, we're here. This analysis doesn't stop. Every step of the way through, not only does the officer have to think about what they're doing right now, they have to think what are the possible consequences of what I'm doing and what can I do differently that may change those consequences to be more positive for everybody and less likely for somebody to get hurt. I will tell you from my experience, and I've got, again, 21 years on the department, 14 years before that in the Coast Guard, if force is used, everyone hurts. There is no winner or loser in force. When you have to use force on somebody, I hurt afterwards. I've had to use force to make arrests, and even when I, quote, win, I still go home hurting. So it's not fun. It's not a situation you want to get into. You want to avoid it at all. Every possibility to avoid it is great. But like we said in paragraph 1, you have to accept and understand that there are times when it's not going to be avoidable. And then what do we do then? And the force we use is analyzed based on all of this that we're talking about. And if you got questions as we go along, please just throw them out, so I'll try to answer what I can. Okay, this is what we teach officers to think about in order to de-escalate a situation or to change the dynamics of the situation so that hopefully force doesn't have to be used. First one is time and distance. They kind of go together. If you're in a situation where a person is threatening you and you can back off and give a little more distance, that distance creates reaction time. We don't run away from a situation, but if we can back up and get in a communication distance where it takes them more time to get to us if they decide to attack, we can maybe bring that situation down by having that extra time, that extra distance to try to talk them out of what's going to happen. Does it always work? No. But most of the time, time and distance is a friend to everyone. There's a point where you can't go so far that you become ineffective. That's the balance. How far back can I move and still be effective at my job to protect the public? And how far does it become too far where now other people are threatened because I'm so far away that I can't respond in time if the person turns their aggression to someone else. That's what our training and our reality-based training is all about. Judging that time and distance and making it work for you. The information we have. 20 years ago, the only time you knew any information about a person's mental state or what they were thinking or what was going on when I first came on was if you happened to know the guy because you worked the area a long time and the name came out on the radio and you go, I know that guy. That's the information we have then. Now, we have our real-time crime center which can look up old calls at the address, can look up a person's name, can check police reports, and we can find out. Mental illness is the big one that comes up. Does the guy have a mental illness? If we know that, that can change our response because we may understand that there's something not connecting right with them at the time. Maybe we can take a different tactic, or maybe we need someone who understands that particular illness to come in and be able to break the communication barrier. Because I am not a psychiatrist or psychologist. I know some basics about mental illness, I know some basics about how to connect with a person and talk to them, but I am by far not the best person on the department for all those mental health issues. We have a whole unit of officers, and if they're available, maybe one of those officers coming out is a better person to do the talking, and maybe that can buy us more time. So again, all this stuff ties together. I have more information, I might be able to buy more time with that, I might be able to create a distance that is safe to operate from, and we can reduce the chance of using force. Isolation. This comes in, can I isolate the person away from being a threat to anyone else? My job as a police officer is to put myself between a person who wants to hurt someone and the public who doesn't deserve to be hurt because they just happen to be there, or the victim in a domestic violence case. If I can isolate this guy away from any other targets, now I've reduced the number of targets he has. Maybe that will reduce the situation. Maybe that will make him calm down because there's not a target anymore for him. Or maybe now I'm the only target, but I can work with me being the only target as opposed to having to deal with 10 targets where they could turn at any time. All these factors play in. Again, teamwork. We used to go in, I'll go back 20 years ago when I came on, 2 cops to a call. And then if it went bad, you called for more. Now we send in 2, 3, 4, 5, depending on the type of call it is. We have better communications, we have better information. We know right away. I'm sure you guys have heard on the news the guy Superman, who actually changed his name to Superman. We know when we see him come out on a call, we send 5 officers. That's the minimum we want to send. Because I've seen him take 4 people on. It takes 5. So if we know we're dealing with him, we're going to try to get at least 5 officers there, because if he does decide to fight, which he likes to do, it's going to take 5 people to bring him down and get him under control without hurting him. If we go 2-on-1 with him, he is so strong and so determined when he does fight that I guarantee a lot of people are going to get hurt. We don't want that. We don't want to hurt him, we don't want us to get hurt, so we bring more people. That's the teamwork. Deploying with all the different tools we had. 20 years ago, my tools were pepper spray, a baton, and a pistol. That was it. If the pepper spray didn't stop him, and the baton didn't stop him, I didn't have much left. Now we have tasers, beanbag shotguns, foam baton rounds, OC spray, and the handheld detonator that puts out a stream. I can get a big area. I can get smoke in if I get other specialized units with that. I have a whole lot of other tools to start trying to get someone to de-escalate before we have to go to deadly force. More tools, more options. And that's our force array. The force array is, what tools am I sending in with the officers? When you go in with just 2 officers, you basically have 2 guns. That's it. That's what you have. In an unknown situation, because we have to plan for the worst, hope for the best. If I got 4 officers there, I can put 1 with a beanbag shotgun, 1 with a taser, and then each of those units is going to have a person with a pistol with them, because now I've got a less lethal force and a lethal force if the situation requires it, but I've got 4 officers now too. And then I've got another officer standing by with handcuffs, because he's going to be the one that goes in and actually puts the handcuffs on if we get compliance from the person. So more tools, more force array. Force array is all the options available to you at one time. This is where supervision comes in. When you have a force array, I can't have an officer with a taser, and I don't know if anyone's ever heard a taser go off. If you know a taser sound, when it goes off, it's very distinct. You know it's a taser. But if you're not experienced, like a rookie just coming out of the academy, that can sound like a gun to them. They hear the pop. So you need a supervisor there to say, we're going with taser. Everybody, we're using taser. Taser, taser, taser. Get the word out so the guys with the guns know we're not going to a deadly force scenario. So they're under control. They know what's happening. Guy uses the taser. If it works, the handcuffed guy goes in and takes him into custody. That's the teamwork in the force array. And the sergeant or lieutenant, depending on the situation, is the coordination of all this. They're coming on scene and telling each officer, this is your responsibility. You're the taser guy. You're deadly force with the taser. You're the beanbag shotgun guy. You're deadly force with the beanbag shotgun. Your guy's job is to stay together. Do not get separated. Here's where I'm going to have you go. You're set up over here. You're here. I'm in charge. Listen to me. I will tell you when we're ready to step up the options. I will let you know if I want the taser fired. The only time we don't do that is deadly force. An officer has to make the decision to do deadly force himself. I'm not going to tell an officer, shoot him. If they know it's a deadly force scenario and they make that decision, and they're right, they have to make that decision right then. It's not an option when it gets to that level. Every officer at that point has to know the law and understand it and make the decision. I can't tell them to shoot. That's the coordination and supervision. Does that make sense? So everybody's on track so far?
Yeah, that makes perfect sense, but it sounds more like a SWAT activation. I mean, the situation's really, does that unfold where you have a sergeant or even a lieutenant on the scene who's giving direction to people who are
Absolutely.
engaging the subject? That's a very regular occurrence.
Absolutely, every day. Every day I have sergeants. I don't have to go out as a lieutenant every day on the call. Those are major things when I'm out there taking charge. But every day I have a sergeant going out to some call with his officers, some of them because they're required to be at, some of them because we just listen to it and go, you know what, that sounds like something I should be there because it could go south. And when you have enough experience, and what happens is, and this is kind of a little side note, as you're developing your time and getting the experience on the department, teams tend to start working together. Teams will bid together. The same group of officers will tend to work together. So it becomes an easier and easier coordination because you know each person's skills and what they're good at, what they're not good at, and how to assign those officers. It becomes kind of an automatic thing, but this is what goes through our head the entire time. And this is my other side note, I teach critical incident management. I don't care if something's a SWAT situation or a regular call for service. It's the same to me. My process and my thought process is the same. When SWAT comes out, it's just more officers with a lot more tools and a lot more time and a lot more communication ability, able to do the same job that I was trying to do, but it got beyond my ability to control with my smaller group. So all a SWAT call to me is it is so big now, I need more people that are specially trained with certain techniques to come on scene and take over for us to try to avoid using force.
So size is the criteria for SWAT activation?
No, it's not. The SWAT activation has very specific criteria about the type of call. What happens is it's beyond the ability of a field unit of officers to respond to. It takes more, or it needs more skills and more training and more equipment than a field officer has. We don't have, if a guy's barricaded in the house with a rifle, most field units are not equipped to handle that, but a SWAT team is. The SWAT team, when they come out, is bigger than any single squad that I can put together. So I can surround the area, but I can't be communicating with the guy in the building. SWAT can do that. I keep everybody else safe on the outside. We don't go away because SWAT gets there. Our job now becomes to protect the public while SWAT does their thing with the person that they're looking at. So you can kind of think of SWAT looks inward and we look outward at that point. But we don't leave. It's not like they take over and we just go back and take another call. We're still there until they're gone. Okay, then other techniques to maximize the officer's advantage. Sorry.
I just had a very quick question about crisis intervention.
Okay.
I was at a meeting, and I think it was when the city council stood up and said that every officer on the force gets some kind of crisis intervention training. Some of it's only a week long. Does that seem adequate?
It's not, every officer at the academy has 40 hours of the training.
40 hours.
They get 40 hours of training once they graduate the academy.
Okay.
And then we go through retraining throughout our career.
Thank you.
So
So
the 40
it was
hours,
very misrepresented to me.
the 40 hours is the basic first block of training. Then we have advanced programs of that too. So
I know that was a side thing, but it seemed to fit in with what you were saying.
yeah, no, we get continual training every year on it to build on what we learned during that 40-hour block.
Okay.
And then the other techniques to maximize an officer's advantage, there's any number of stuff, and I'll give you the example. I've trained in martial arts for 20 years.
You can't take pictures.
My ability to go hands-on with somebody is different than another person's ability who doesn't train the same style I do. If you're a mixed martial artist, like one of the guys that works for me, he has a different skill set than I do. Those are the other options. What he can do and what I can do and what someone who doesn't train to fight at all can do are all these different options that are available to us. So those are our other skills. Just because I have training outside of what the department has taught me while I was on, because I started my training when I was a teenager, doesn't mean I violate the department policy, but can I use it in accordance with the department policy to give me the advantage of stopping the fight? If I recognize the person's going to fight with me, as a fighter, I will probably recognize that faster than a non-fighter. So I'm expected to be able to step back, make time, distance, and do all these other things quicker than someone who's brand new that doesn't recognize the fight about to develop. And if you've ever ridden along and seen a recruit officer in training, you will see at some point where the training officer is telling him, get back, he's about to fight. They're pulling him back because the experience isn't there with the new guy, but the older guy with more experience is recognizing this isn't working. He's starting to step it up where he's going to fight with us, so let's back off and give more time. You will see that regularly if you go out with and see recruit officers in action. Unfortunately, most of the recruit officers end up on graveyard, and we don't see many people out at 3 o'clock in the morning to do the ride-alongs, but that's the difference where experience comes in. All this other stuff, you can only gain by experience. And that's why it's so critical to us to not have all the rookies together. We want rookies and experienced officers working together so we can build this training and experience without anybody having to get hurt. Okay, now we're going to get into paragraph 3. This is where you're going to need some background on Graham v. Connor. I'm going to guess, is there anybody here who's a lawyer? Because you've probably read Graham v. Connor if you are. If you're not, and you've read all of Graham v. Connor or Tennessee v. Garner, then you're probably like me, a use of force junkie who wants to understand all the case law. Just to give you a background, Graham v. Connor is what started all the analysis. It is the main case on how use of force is reviewed. But to understand this, you have to understand how we got to Graham v. Connor. And that's Tennessee v. Gardner, which happened in 1974. So I'll give you a quick background so you can, as we talk about this next part, you kind of understand. Tennessee v. Gardner. Gardner was a 18, 19-year-old burglar. The officer caught him in the act of a burglary. Gardner ran, was ordered to stop. Gardner decided to try to jump over a fence. The officer drew his firearm, ordered him to stop again. He didn't, and Gardner got shot and died. Now, anybody see a problem with that? In 1974, that was perfectly legal. The law for a fleeing felon said, and this was pretty much throughout the United States, that if you were a fleeing felon, deadly force was authorized. That was the law. Okay? It obviously went to court. It became Tennessee v. Gardner, made it up to the Supreme Court. To show you how long this takes, this happened in 1974. It was 1984, 85 when the Supreme Court finally heard the case. For that 10 years, the law that you could shoot a fleeing felon was still in the books because the Supreme Court hadn't made a decision yet. Now, I will tell you, most jurisdictions and most people just instinctively do not just shoot a fleeing felon. But it was legal. In this case, what happened after Tennessee v. Gardner and the Supreme Court ruled, one, there was a lot of people that thought the officer had committed a murder. They said, no, he didn't. He followed the law. He did exactly what he was allowed to do. There is nothing you can do against him because what he did was legal. The problem is the law was wrong. That doesn't make the officer's actions illegal. It means that the government should not have had that law on the books, and we should have changed it a long time ago. So now Tennessee v. Gardner said you can't shoot a fleeing felon. You can only shoot a fleeing felon who is a threat of imminent harm or death to the public. They narrowed the law. They made it more specific about when a fleeing felon can be shot. We have that in our policy now, the violent fleeing felon rule. The crimes that we list that say these are considered violent crimes, and a person that runs with these crimes is considered a violent fleeing felon. Does that mean we can still shoot them? No, but now it's a narrowed interpretation, and if they meet other criteria, deadly force may be authorized for this crime. A year later, the Supreme Court ruled on Graham v. Connor. Give you some background on Graham v. Connor. The police officer is walking down the street, sees a gentleman get out of a car pulls up to the convenience store, gentleman gets out of the car, runs into the store, is in there for less than a couple minutes, runs back out, tries to jump back into the car. Anybody here want to guess what the officer was thinking? Robbery. Okay, is robbery a violent crime?
Oh,
Yeah, robbery.
it is, yeah.
Robbery, because most of the time you rob something, you're armed. It's considered generally it's probably going to be a violent crime. So the officer responds to the robbery, goes to catch this guy. They end up in a fight. Guy ends up with a broken arm. It all goes to court. because the gentleman who got tackled and fought the officers and ended up with, I believe it was a broken arm if I remember right. He might have had a broken leg also. Turns out after the fact they find out that he was a diabetic who had asked his friend to drop him off. He ran in to try to get some orange juice. There was too long a line, so he ran out to ask his friend to take him to another store. But gets in a fight with the officers. He does actively resist when the officers tell him to stop. That's when the fight occurs and the injuries occur. That makes it to the Supreme Court and led to another whole series of rules. Now, was the officer wrong in what he did? This case is why I don't talk about cases without reading the entire thing. Because the officer, and what Graham v. Connor said, is that officers, if feasible, should use the minimum amount of force necessary, but there's some rules. And this is where objectively reasonable officer standard comes into place. And this is what causes all the confusion between law enforcement and the courts and the public about how these cases are decided. And that's what I'm trying to get across. I'm not trying to convert you to think like I do, because we will all look at cases differently based on our experience and background. I'm just trying to get you to understand what the courts said as a standard, so when you're reviewing a case or looking at a case, you can understand what we're looking at when we review it. First is, the case must be judged from the reasonableness, or from the perspective of a reasonable officer on scene, not from 20/20 hindsight. So when these cases go to court for excessive force on an officer, one of the first things the jury's told afterwards is you can only judge it under these rules. What would a reasonable officer in the same circumstances have done? Not what would you have done, not what would I have done. What would any officer with that training and that background and that information have done in that situation? In this case, they ruled on Graham v. Connor. He was very reasonable to believe the store had been robbed. That was a reasonable decision. And trying to stop the guy who he believed just committed a crime based on the information he had at the time was reasonable. All the stuff they learned about the diabetes and that afterwards cannot be used when you review an officer's use of force, because the officer didn't know that. That was not information he had at the time he made his decision. You can only look at what he knew up to the time force is used and before that. Anything you learn afterwards doesn't matter in the analysis. I'm not telling the jury how to rule, I'm just telling you this is the analysis part. The other thing it talks about is that courts, and this is the Supreme Court, and the Chief Justice wrote this opinion, courts have to recognize that officers are often responsible for making split-second judgments on rapidly evolving uncertain circumstances. So the Supreme Court actually told all the courts in the United States, you have to understand that the officer has to make a split-second decision. And all this information that's in his head, he has less than a second to act on and decide what to do. We always say that we have to, in a deadly force scenario, we act in milliseconds and we're judged in years. That's where that comes from. We make a split-second decision based on everything we know. I could be standing right next to an officer who knows something about an offender that I didn't get told about, and it's what I knew when I used force that's important, not what the officer next to me knew. If in the analysis it comes out that there's information we should have known, that's training and policy development, and what does the department do after that to make sure that never happens again. But it doesn't affect my decision to use force. The fact that information wasn't available to me. Court said you have to understand that, and you have to take that into account when you analyze the use of force. Okay, they also said though, but that doesn't give an officer a free rein to just say, well, I didn't know that. They came up with 3 criteria. These are the objectively reasonable criteria. We call this a gram factor analysis. 3 things you have to look at for when force is used. 1, the severity of the crime. Shoplifting versus armed robbery. 2 different levels of severity, both involve stealing something, right? Armed robbery involves pointing a weapon at someone and taking it. Shoplifting is walking in, taking it off the shelf and trying to get out without being seen. Do you think those 2 crimes would justify the same level of force? No, we want to try to stop both of them, but the armed robber is a much bigger threat to the public. The shoplifting, we want to try to stop him, but I may not be justified in tackling him. just on that. The second one, does the person pose an imminent threat to the safety of officers or the public? You have to look at the totality of circumstances. I'll give you the classic example that I saw when I worked in Northwest. Guy shoplifts at a Walmart. So far, so good. Security watches him. They go out the building. They call us. Police officers arrive on scene. He gets out in the parking lot. We're still dealing with a shoplifter. But as soon as he sees security or a police officer, he pulls a knife out of his pocket. Does that change the situation? Absolutely. I'm not dealing with a shoplifter anymore. I'm dealing with a guy who's doing an aggravated assault and potentially wants to stab one of us. It's a different crime that just occurred now. Most people look and go, well, he was just shoplifting and then he pulled a knife. What's the big deal? He was just shoplifting. He became an armed criminal at the time he pulled the knife out of his pocket. Everything changed at that moment. And that changes the analysis. And then third, is he actively resisting or trying to escape arrest? And I should go back to the second one. It's not just the safety of me. What threat does this guy pose to the public? If he's running away from me, but he's got a gun, and he just pulled an armed robbery, is he a threat to you? Absolutely. If you're driving by, is he a threat to injure you? If I can justify that threat, it may be a situation where I shoot the guy in the back, but I'm not shooting him to protect me, I'm shooting to protect the public. And if I know about him, like this crew of armed robbers that we just arrested, that was pulling armed robberies and carjacking people afterwards to change the cars, that changes the situation. I will never tell you it's right or wrong. I don't review every single case all the way through. That's what the juries do. The juries say, yes, justified or not justified. This is the analysis that they go through. If he's actively resisting me and trying to fight me, then the level of force I have to use to make the arrest could go up. How does that come into play? Okay, I've told you I've done martial arts for a long time, but I'm also older now. 20 years ago, I was a lot more ready to go hands-on with someone and try to take them into custody by grabbing them and trying to get them to the ground and do all the cool little takedown things I learned to control him to the ground and get his arms behind his back and cuff him than I am today. Because, one, I get hurt faster, I'm older, I'm not as fast as I used to be, and the chances of me getting hurt are much greater now than when I was 20 years younger. I have to temper all that. If I'm fighting a person, I can tell you, I've been interviewed, I've never worried about somebody kicking me in the leg and breaking my knee. But I do have a healthy respect of that possibility happening. And if I do get injured, the level of force I'm going to have to use to protect myself and to stop a guy who may not have been a big threat in the first two until he started to fight me, but once I'm injured, I'm at a greater risk now and my level of force may have to go up. There's also what we call disparity of force that comes into this analysis. I will tell you, I know a female officer on this department, she's probably this tall, 95 pounds soaking wet with all of her duty gear on. She is the meanest little fighter I've ever seen in my life. You would not know that she could fight this good. But if she's taking on a guy who's 6'4", 250 pounds, I don't care how good a fighter she is, she's tiny, he's big. Does that change the situation? That's disparity. Injuries, if an officer gets injured during the fight, that's a disparity. All these things have to be accounted for, and if you ever have to sit on a jury, which I hope you never do, because when you're sitting on a jury for a case like this, you're talking somebody was seriously hurt or killed, and you're deciding whether or not someone did something wrong. I will never be selected for that jury because of my job. I will never be selected for it. But you have to sit there and take all of this into account, and these are the rules they're going to tell you to look at and to analyze before you decide whether the person did something right or wrong. Okay, so after you get the grab factor analysis, then we explain to the officers in the policy that unreasonable force will subject you to discipline, and this could include criminal prosecution and or civil liability. And this is where it gets complicated. Okay? Grab factor analysis. If the answer to any of those three questions, go back to it. Was the severity of the crime justify the use of force? No, then you can't use that force. If it's not justified by the severity of the crime, you can't do it. Was he resisting you? No. Well, then you can't use force on him. I don't care if he just committed a murder and is holding the gun in his hand, he puts the gun down and says, I give up. You can't hit him. I am not the guy to arrest a child abuser. That is my button. I know that's my button. My partners know that's my button, and that's why they say, I will arrest him. You go stand over there with the victim and make sure they get treated. Because that's the one guy that can probably push my button and make me do something stupid. But I've learned over the years to control that, and my partners have learned over the years what we're all good at. Okay? I can't hit a guy who abused a child and says, I give up, I surrender. As much as I may want to. As much as I may find what that guy did is disgusting, I can't take it out on him, and I won't. Because that's not my job. The jury's job is to decide what the consequences are. But I know it's my trigger, so why would I put myself in a situation, if I can avoid it, where that could potentially happen, because I know my weaknesses. I know what bugs me. If I got a partner there that can handle it better than I, let them make the arrest. I don't care who puts handcuffs on somebody. That's how I avoid this. Does he pose an imminent threat to the safety of others? If the answer is no, you can't shoot him when he's running away. You can't throw your baton to take out his legs. We don't train that anyway, but that may be justified if you're trying to catch a murderer, and that's the only way you have to stop him. Not a trained technique, but it might be the only way you can stop him. I can justify that if all these things are correct. This is what you're doing on a jury, and this is what juries have to sit and look at. And they are told, usually if you watch the trials, it's a whole day of instructions on how to do this analysis. Here's all the things you have to look at, here's all the things you have to consider, here's what you cannot consider. Now, you've had all the evidence, go sit back there and tell me if this guy did something wrong or not. If we find that an officer is used excessive force unjustified, then we look at all of our other policies. Excessive force and abusive can be two different things. Does it mean everyone's going to get fired? I can't tell you that without looking at the case. But if it's a civil rights violation, they're open to it and they're probably going to get fired for a civil rights violation. If they made a mistake and did that one extra hit, when we all look at it and go, you know what, that extra hit wasn't necessary, but you're going to pay a price for it, but we don't need to fire you because you don't have a history of that. We can train you, repair this, make sure you don't do it again. You're going to pay a consequence for taking that last shot that you should have stopped. It's just an example. I know some people think we should always fire them. It's not always the answer. Just like firing a good employee that makes a mistake is not always the answer. Sometimes you can fix the problem and it won't happen again, and that's good too. Civil liability is the biggest one. If you use unjustified force, you are not protected under what's called the color of law. Color of law means that I did all my duty, and this is what Tennessee v. Gardner, this is why I tell you about Tennessee v. Gardner, because he was operating under the color of law. The law was wrong, but when he shot the kid jumping over the fence, committed a felony, he was operating under the color of law. He was doing what was legally justified at the time. So that officer was protected. He could not be held responsible for a crime because he didn't commit one. And he couldn't be sued civilly because the law allowed him to do exactly what he did. The law was wrong. Most officers understand and don't do that shooting, but this is a case where that law was on the books for 30-some years, that you could shoot a fleeing felon. That goes way, way back. The beginning of police departments, that law existed. It wasn't until 1974 when someone said, that's not right. Now, do I wish we had caught that earlier? Sure, of course I do. I don't like to see somebody die that it's not necessary. But it took till 1974 to catch it. It took till 1985 to fix it. Same with Graham v. Connor. It took until 1986, 10 years after the incident actually occurred, for the courts to say, you know what, there's got to be some guidelines more than what we have. We don't have enough guidelines on how to use force. We need a criteria that you need to be able to evaluate it by. That's why Graham v. Connor is so important. And once you understand those three guidelines, hopefully you can look at a use of force case and at least start, this is how the lawyers, this is how Internal Affairs, this is how Civil Rights Division for the Department of Justice are all looking at these cases. This is the criteria they're looking at. And when they decide to charge someone or not, it's because it didn't fit one of these criteria. And like I said, I'm not trying to change anybody to look at my point of view. I don't even make decisions on the officer-involved shootings I know in our department, because there isn't one of those cases that I've had the chance to read the entire case, to read all the interviews, to look at every piece of evidence and make a decision. I let the courts make the decision. I just look at the information I know and figure out, can we train something better so we can avoid this the next time? That's what guys like Lieutenant Erwin and I do. We look at it and go, how can we make sure this doesn't happen again if it's not necessary? What can we do to be better at this? Okay, and then we also tell officers, be prepared to deploy various options to control a person if something you're doing isn't working. If I'm tasing a guy, and for those of you that don't like cussing, pardon me, but actual situation happened about a month ago. Guy got tased twice as he was trying to attack someone, and he actually looked at the officer and said, that shit don't work on me. Well, what's the use of doing a third tasing if the guy just looked at you and said, do it all you want, that's not going to help. You're not going to stop me with that. Why would I keep doing that? I have to think about this and realize what I'm doing isn't working. I need to change my tactic. Taser doesn't work on everybody. Chemical sprays don't work on everybody. Sometimes you have to go hands-on. Sometimes a beanbag round will hit somebody and they'll be like, okay, I give up. But they'll take a beating with a baton forever for some reason. I don't know why it happens. A lot of times it's drugs and the effect that the drug has on a person can change it. Sometimes mental illness has that effect. Sometimes people are just plain tough and they will fight through stuff. You change your tactics. If one thing's not working, switch to something else. Try to get a good outcome. That's why we have so many options now. That's why we don't carry just a baton and a pistol. If the encounter changes, if the guy's running from you and you're chasing him, and then he suddenly falls down and stops, you can't dogpile on top of him because you're tired of running. You have to learn to turn, veer off, take a position of control, and start giving orders to the guy. You have to stop the aggression and try to change the tactic, and if he'll surrender and put his hands behind his back, then you didn't need to dogpile on him. But if he's trying to push himself back up and get away, or he's reaching to grab a stick on the ground, different situation. Now you've got to stop him. You have to make that decision instantly. Change your tactics. That's what all of our use of force training is about. All of it, since 1986, revolves around Graham v. Connor. And until a better case comes along from the Supreme Court, and I will submit to you it's probably like Roe v. Wade, you're going to need something huge to change this. Okay? They're the laws of the land. This is what we have to work under. Okay? We wrote into our policy that you will use the minimal force within the objectively reasonable range. Okay? Because what's objectively reasonable for one officer may not be objectively reasonable for another. We want our officers to use the minimum force that is objectively reasonable under the law when they have to use force. Ideally, we don't want to use force. But if we have to, then we're going to try to use the minimum amount to achieve the job. But that doesn't, minimal force and minimal objectively reasonable are two different standards. And we don't do minimal force, that's not the law. Minimally objectively reasonable force is the law. And that's what we train our officers to decide. So that's what I've been talking about, and I'll be doing this for the next year at the Foothills, and I will make the presentations available to CPC, to Selena, to anybody that needs it. I can't guarantee I can be available for everyone because I have a kid in gymnastics, but I'm happy to answer questions or whatever they forward me, I will answer. I taught use of force for several years. I taught DWI for several years. I've dealt with these guys on different levels. I worked the Southeast for the last 4 years until I moved to the Foothills on day shift. So I've seen the range. And I can tell you from the officers I work with, we try not to use force. Yep.
I do got a question for you.
Sure.
I know you were talking about case law, and the one that I know of way back when I was doing this stuff was we used to follow the Miranda warning,
Right.
which is really about protecting life and property, and actually doing the actual warning before we actually did anything with anyone. I don't hear that anymore from you guys, from officers anymore, that we used to, that was just a standard. you know.
We give Miranda warnings, but Miranda warnings only apply when you're in custody. When I go, Miranda warnings is an in-custody procedure.
Not where I was taught.
Well, I'm just telling you what the law says. We give Miranda warnings actually a lot of times when we're not required to, only to tell people of their rights. Miranda is only required when you're in custody. And if you're not in custody, we'll have to agree to disagree, because Miranda is an in-custody procedure. It has nothing to do with force. It has everything to do with protecting.
It's about life and property.
It has,
Protecting life and property.
there's where we'll disagree, and we'll just have to agree to disagree. Miranda is about informing a citizen of their rights when they are a suspect of a crime, and what their rights are. It has nothing to do with property. Unless you're a suspect of a property crime, but it has nothing to do with taking your property or going on your property. It has to do with everything with what your rights are when I'm about to question you as a suspect of a crime, and I've detained you to where you cannot leave. That's in custody. Custody doesn't mean
Maybe you don't
handcuffs.
understand what property is. This is property.
No, I get that.
A man or a woman's property. This
I get-
is my property, that's your property.
I get that.
You
It's a
are to
Fourth-
uphold, protect life and property.
It's a Fourth Amendment issue, and when you are in custody, which means you're detained, not necessarily handcuffed. If I'm preventing you from leaving, you're in custody. If I'm going to question you about something, I have to advise you of Miranda rights. We do that. But what a lot of people misunderstand in some cases when they watch videos, a person's free to leave and they talk to us, I don't have to advise them of Miranda, even if they're confessing, if they were free to leave. So if I come up to a guy and say, hey, we're looking for a white guy who was wearing a blue t-shirt that ran and just committed a robbery, because like, no, I didn't see anything, I just committed a murder. Okay, well now you're in custody, and that statement to me can be used against you, because I wasn't detaining you when you said that. But now if I'm going to question you further, now I have to read Miranda. But that's a totally different topic. That's completely outside of Graham v. Connor.
Yeah, it is, but this is a 1966 case.
I know.
You're talking about a later case. So what has precedence? A later case or an earlier case?
Miranda doesn't have anything to do with use of force. It has to do with interrogation.
Sure does, because it talks about protection of life and property.
Okay, I will give you, Miranda was 1966.
Yes.
Until 1986, the court said that when I held you in custody, that was a 12th Amendment issue. In 1986, when this came out, they said, no, it's 4th Amendment. So there was a big disconnect between those two from your viewpoint of it. But Miranda does not have anything to do with force. If you're barricaded in a house, I don't have to read you Miranda before I tell you to come
It's not
out.
just about reading the Miranda, it's following the Miranda.
Miranda's just an
You can
advisory.
read it, but it's not just about quoting the warning.
Miranda's an advisory, that's all it is.
Excuse me. Does the police, civilian police oversight commission, do they review all use of force incidents or cases?
They have a representative that sits on the force review board that reviews all those cases. So there's a percentage that they review of non-serious use of force, and they review all serious use of force. But I think we have to review 10% every month of the cases that are not serious use of force. But all serious use of force are reviewed by a board, and the police oversight is part of that board.
And if that incident is taken to court, are they also part of that court procedures?
No, you're talking the difference between an administrative investigation and a criminal investigation. Two different investigations. If it's going to court for criminal charges, that's one group that investigates it, puts the case together for criminal, and then we have an administrative review. We can actually have a case where an officer is looked at and they say, there's no criminal charges, but we look at it and go, yeah, there wasn't anything criminal we can charge you with, but you violated so many procedures, we're firing you. Because it's administrative things that you did wrong. And that it becomes, the courtroom charging, and this is what I'll tell you, the same thing I told you for those guys. When you're sitting on a jury, it's tough enough. When you're sitting on a jury with a police officer as a defendant, my experience just from watching the cases and watching how these cases pan out, that's an even harder jury to get to, because no matter what you do with a jury, there's usually somebody on the jury that thinks the guy was guilty and somebody that thinks they weren't guilty. And when you become a polarized job like a police officer, it becomes harder to change that one person's mind And that's when you get the hung juries. And I'm not gonna try to kid you. I'm convinced that anything charging a police officer is gonna be harder to get it past a jury because of that. Because how do you screen out from a pool of people and guarantee that you didn't get one person on the jury one way or the other? All cops are bad or all cops can't do anything wrong. And how do you make sure that neither of those ends up on the jury so you get a fair analysis? I don't know. And God bless them for trying to find a way. But I will submit to you that from my experience watching these cases and how they go, that becomes even harder when it's a polarizing position like a police officer or a politician or some of the public people that you see. You know, you look at the O.J. Simpson case, there's a large group of people that thinks he's guilty, there's a large group that think he's not. Would we ever be able to find a jury that could overcome that? Same with police officers. It's hard. And I think juries overall do their best to make the right decision, and when they get hung, is because there was a group on there that said, no way, and there's a group on there that said, I'm not changing my mind either. And now you can't put that in jail if there's not a unanimous decision. And that's why our justice system works so well. But are you always happy with the outcome? No, you're not. I'm not. And I've seen it both ways. I've had people that got convicted like, you should have won that case. I don't know what the jury was thinking.
Question
I'm
on,
sorry, could I?
I'm sorry.
May I have a question here? Okay. I just wanted to, while you were talking, I wasn't familiar with Graham versus Connor, but I just wanted to clarify something, which is you depicted the scenario, which was that somebody ran into a store and then ran out and then was tackled by a police officer. But I just wanted to clarify that Graham in that case was actually a black man, and that he ran into a store, ran out, got into a car, drove away, and that car was pulled over, that Graham exited the car and passed out on the curb, and then was arrested by police officers, and then was injured because while he was in cuffs was smashed against the car.
Okay, that's not the full case. I don't know where you're reading the summary.
Okay, I just read like a summary of the testimony.
Okay, the summary is leaving out part. There was a fight. I went through a very short synopsis of it because Graham v. Connor
Can I finish my question?
is a 4-week case to study in
Okay. Well, the reason I'm bringing it up is because, you know, these, as you pointed out, this case law all existed before the Department of Justice identified an issue with the APD having an issue with excessive use of force.
Okay.
So, and I know that you have been talking about how, you know, it's really difficult if you're not the officer to really assess what was objectively reasonable in a situation, but we're here because the DOJ concluded that the APD does actually have a problem. And so I'd actually be curious about what it is that APD is doing, given, you know, this is a case law, these are the regulations to address the fact that officers are using force when there seems to be some disagreement about this objectively reasonableness of their actions.
Okay, well first I'll tell you, if you heard me saying that it's difficult for you to understand because you're not cops, I don't believe I said that. What I'm telling you is this is the analysis you have to understand how an officer's use of force is reviewed. What we're doing is reality-based training. We're trying to create scenarios so officers learn how to react in different situations. Before it was a lot of classroom training and not a lot of hands-on application afterwards. So you learn the law, you learn some techniques, you may spend once every 2 years learning how to use a baton. And then the year after that, you may learn how to do a armbar takedown. Well, now we're teaching and then following that up with reality-based training where there's scenarios that involve what we teach so that you can learn how to apply this properly. Right? The DOJ thing led to some good stuff. Part of it is this reality-based training.
Is the reality-based training dealing with implicit bias in any way? So the tendency that has been documented of officers to judge brown people, for example, as more dangerous, or to view them as older, or to, so we could list off a huge list of unarmed black men who have been in this country, who have been, and I'm not talking about APD right now, but it's that who have been murdered, or, well, you would argue with that, I guess, who have been killed by police. And there does seem to be this issue of implicit bias. Is APD trying to deal with implicit bias?
I would say that use of force training doesn't specifically look at implicit bias, because what we're focusing on during use of force training is those use of force tactics when it is appropriate and not appropriate to use force. We have other trainings that deal with different implicit biases. In fact, the cadets tomorrow at 7 o'clock in the morning are having a cultural sensitivity diversity panel. And we have all different cultures that are represented and different faiths, different beliefs, different types of people on that panel to talk specifically to the cadets. So the best, I went through that training last year so that way I'd be able to tell you like how it works and what they get out of it. They take the perspectives of those people, the history within those cultures or maybe dealings with, because we know that bias cannot just be color of skin. It also could be, sexual orientation or different types of belief systems that would exist within a culture, right? So those people that may associate with whatever culture or belief it would be, give their previous history and experience with police officers. And it might be Albuquerque specific, it might be different area specific. Then they walk the officer through when I'm dealing with you as an officer, I'm feeling and my perceptions going into that would be, and then what I believe your perceptions and dealing with me are. And break it down to where there's things that you can learn within investigations that would help you more easily as an officer. The best example I can give you is within the Asian culture, they're very patriarch oriented. So if there was a chaotic scene and I'm an officer responding to that scene, I know that I'm most likely to get information from the male figure in that family because it is the way their culture is structured. As opposed to in a Hispanic culture, it's more matriarchal structure. So I'm more likely to get information from a mother or a grandmother in that case who might be more protective in that scenario. But then they look at the implicit biases and they're able to hear it from the actual perspective as opposed to a police officer just say, well, there are implicit biases because of blacks and this race relations that happen within that. They hear it firsthand from the person that's experienced those biases and really connect. So we're hoping to put out a video of that training so that you can see it and look at it and review it and see what's being taught there. This will be the second installment of that training. So that's starting at the cadet level. To take that up a notch, we've done cultural sensitivity training as part of the settlement agreement, and that's a 2-day block. I think it's 8 hours each day. And within that, there's different videos from different perspectives to the officers. It's not as open and dialogue-oriented because there just wasn't the time. But the goal is to take this dialogue-oriented training and roll it out department-wide. So it's not directly used in use of force, and we don't really want it to be because you don't want to look at force when it comes to different types of races. We're backing it way up and looking at it from everything from a traffic stop to the way you take a police report. So that way it starts at the beginning as opposed to maybe the result. Does that make sense?
It ties into our training because it's one of the things you can do to try to avoid the force in the first place if you know the contact. And it's not just races. If you stop a group of banditos versus an individual one, you find the leader of the group and you talk to them, and you can avoid a fight that may occur because that leader will tell the guy, hey, they need you because your bike's not registered. Go talk to them, we'll be here, you cite and move on your way. But if we try to go right to the guy on the bike and we don't honor their structure and at least admit that there's a structure and recognize it, it could get worse. So it's cultural, it's groups, it's gatherings and organizations, it's race, it's all of that. And I've gotten training throughout my career on cultural sensitivity. We've stepped it up a lot, and it's probably better now than when we first started. But it is a big, you have to understand these cultures. There's a large Muslim community in the Southeast. You have to understand the culture to try to avoid because if you do something wrong, it will. If you violate a cultural taboo, even inadvertently, you could end up having to use force because you offended someone and you didn't even know you did it. And that's what we're trying to get everybody to understand.
I think too it's important to note that when DOJ came in to investigate APD, That was one of the things that the administration specifically asked them to look for, was bias-based policing. And in pretty much every settlement agreement that we've seen across the country, they found some form of bias-based policing. They didn't in Albuquerque. And we specifically asked them to look for that. Because it's important, and it's important to our community, especially when we're so diverse in New Mexico and in Albuquerque. So they have not found any evidence of bias-based policing here at this point, but we'll continue to be open to them looking for it, and you as a community to be reporting that and looking for that as well.
May I ask one more question? Sorry, Chris. So I was just curious, how many female officers or in what percentage are in the
I have to pull it, I think it's about 13% female officers. In March, we graduated the largest female cadet class in ABQ history, and out of the 28 officers, 10 of them were female.
So I would just ask you, as somebody who's obviously in a training position, that you become sensitive to your use of pronouns, because you always refer to police officers as guys and he. So just something to consider out of respect to...
I will try to tell you that 87% of the guys I deal with are guys, 13% are girls. I will,
women.
or
Thanks.
women,
Yeah,
females. I'll try to be more open to that.
thanks.
I was going to ask you something, because there's lots of research on how if you're always using a specific gender pronoun, it makes a difference in the attitude of who you're teaching.
And I appreciate that. I mostly teach cops, so this is a new experience. I'll try to incorporate that into my training. And be better about it.
Women as well.
No, I get that. With cops, a cop environment, I will tell you, you get cops in training versus anyone else, it's a completely different group of training because it's a different attitude.
Sure.
And so, but I will try to work that in.
Hopefully you can speak candidly on this.
I have known for that, that's why I'm only lieutenant.
What can I tell people who ask me, what are the most important changes in APD use of force training that should make them feel better that inappropriate use of force will be reduced within the force? What are the most important changes in the training recently that you, in your opinion?
I was going to say, as long as you understand this is my opinion, because if you want the department's opinion, you're going to need to get that from the chief. In my opinion, the best thing we've done is reality-based training. Tying all of our classroom training to some sort of hands-on practical scenario on how that can be used. And we actually stop an officer if they're going the wrong direction. If they're starting to escalate on the force and they're missing signs that tell them that's not necessary, you don't need to go hands-on, you haven't tried this, we actually stop the training, reinforce the behavior we want, and then we redo the training with them. That's probably, in my opinion, the best thing that's come out of all of this. And the second part would be a much better understanding of the actual laws involved.
Just to follow up quick, maybe just in terms of hours, how much more reality-based training is there? Is it just the amount, or have you also brought in people with more expertise in reality-based training?
Our reality-based training didn't exist before the settlement agreement.
Wow.
Not the way it is now. What we did before was, okay, you need to learn how to do an armbar takedown, so we go into the gym and you do an armbar takedown. But it wasn't the cadets would receive some of, say you're on a traffic stop and the guy runs, and you go and chase him and catch him. That's not reality-based training. That reality-based training now is, here's your situation, it's a domestic violence call, here's what you've got. Now, just like a dispatch, the officers go in, and as they walk in, they start hearing things, they start seeing things, and how are they going to react? And we are equipped up with dye marking rounds to take our weapons away. We have basically paint pellets, but they fire out of a handgun just like we carry. They have pepper spray that marks, they have foam, everything that we carry, they have so they can use it during the training. And if they're going the wrong direction, we stop. Every time we do a maintenance of effort training, like this year we have a full day on use of force, followed by 2 full days on reality-based training on use of force. In the last 2 years, I would bet I've gotten 80 to 100 hours in the reality-based training. In addition, we brought out the person who created the reality-based training platform that we use, who has trained instructors and evaluators in it. He's done 2 classes. I think he's scheduled to come out for a 3rd. And there's a separate class to train the role players and a separate class to train the evaluators, so that you never mix the two. Your evaluators are evaluators. Role players are role players. They have a different job. And you're trained to be a role player and how to follow the script and how to react to the officer's cues. So if I say something wrong, he's trained how to respond to that. And if I don't correct it, the evaluator steps in and says, nope, you went the wrong direction. Now let's try it again. And so that's what...
So it's not just a quantitative difference in the training, it's really a qualitative,
It's-
a big qualitative difference.
It is light years ahead of what we did even 4 years ago.
And
Have
Karen,
you been able to see the difference?
Yes, our recruit officers are coming out much better equipped to respond to most calls. They don't have the experience to make some of the snap decisions that have to be made, but they are much better at understanding the direction the call is going in the beginning than they were.
But I mean, the officers on the ground have seen a difference in terms of de-escalation, like minimal use of force, we've seen that actually.
My use of force reports, and this is my experience, the use of force reports I review are much more lower level stuff. I don't get as many of the injuries or the hard takedowns anymore because I'm having a better response by the officers. They're coming in as a group, and instead of having to take one person to slam a guy to the ground to stop him, 2 guys are able to grab him, or women, or men. 2 officers can grab the person, catch him, and control the takedown. So now they're not injured on the way down, and the arms are in control, and they're handcuffed. So my experience is I'm seeing, I'd have to look at studies to see if there's less force as far as total numbers of reports, because that I just don't have the data on. I know for mine, what I'm looking at, we're reporting a lot more than we didn't consider force before because of the definition in the CASA agreement, but the level of force used is much, much lower. And so I think that's a good thing. I have a hard time saying you can compare it before the CASA agreement and after, because the definitions changed with that settlement agreement. Things that no one considered force before. And I'll give you an example. If I go to arrest somebody and I grab their arm and I'm escorting them out to the car, and they pull away and I have to grab them and pull them back, that's force. We never considered that force before. That was just, he's trying to get away, I had to stop him. I didn't do anything else, but I had to grab him and pull him back because he tried to run away, or she, if it's a female offender. But they tried to run away. I had to physically grab them and overcome that resistance. That's force. I would never have reported that before CASA as a use of force. Because before that, use of force usually involved some sort of hard takedown and or injury.
KRQE did we let them go through our use of force and reality-based training. And so if you go to KRQE's website and Google APD's new use of force training, you can watch their story on it and watch what it looked like and look at and see from the reporter's perspective what that training looked like. And we did that on purpose so that it wouldn't be APD showing you what the training looks like. We wanted somebody unbiased to come in and look at it.
JP.
Yes, thank you. Officer, thank you for your presentation. One thing that I don't see here is I don't see any zero tolerances. You talked about discipline. You said, I do agree with you, there are certain levels of extension that you have an officer that may get out of line, brings him back into line, still a good officer. But we as the community, or I as the community, I can't speak for everybody, I see a credibility of discipline within your own rank and file. And that alludes all of you taking it onto a court scenario, onto a jury scenario, which creates a gap and a division within the community. Then it's played on with the media. Why isn't there any zero tolerances within your procedures of any kind that say this occurs, this is zero tolerance? I don't see that anywhere in the SOPs.
I can tell you that there was a zero tolerance issue that happened just last year. So So you heard about the cadet that reported that there were two
No,
officers
I
that
understand.
he was fired the next day.
Yeah,
That
right.
officer was 0 tolerance, fired the next day.
Are they written down and where do they come into play? So
Yes.
that we know that if we have a complaint and we go before the CPOA, the system also, we can allude to that policy and say, here you are, I'm filing a complaint and it's a 0 tolerance issue. Why isn't it acted on?
Within,
It seems to me that the complaints that I have seen filed with the CPOA is based on the fact that people want some type of action done within your department to act within your own department.
Well, I can tell you, if you want the CPOA opinion, you're gonna have to get their director out of here, because I can't tell you how they decide their cases. They are completely outside of the police department. I have no input into that.
No, I
And I can
understand.
tell you, if you want to know what a 0 tolerance policy is, you can't write 0 tolerance for something, because the number of facts, this is use of force policy, that's all I'm talking about.
Right.
I'm not talking about an officer who commits a rape. There's 0 tolerance for crime. You commit a crime, you're subject to termination. There's an investigation, there's a process, there's due process involved to everybody. If you want to know what we consider a termination offense, in the departments on the site, you'll see these little numbers in the box. Those are the sanctions. Anything that says a 1, that is a termination offense.
Okay, that defines what I'm asking.
But
Thank you.
you can't write for use of force, there is 0 tolerance for this action, because all these factors have to be analyzed first.
Okay.
And if the force is justified, even if you didn't agree with the force that was used, if it was determined to be justified, you may not like the outcome, but that's the decision that was made, and that's the end result of the case. And that's why I don't review my use of force. My boss looks at what I do, it's reviewed by someone above him, and it's reviewed by a completely different division after that. And if they believe it's criminal, attorneys are going to look at it, and other departments. And that's why we've started all these interconnections.
Okay.
and that on the SOP is called the disciplinary matrix, and it's on the website, but I can bring you a copy of it as well.
Okay, you can email that to me.
Okay?
The other question, in response to your CPOA and how they respond to it, in attending some of the CPOA meetings, the directive was, and they're asking for this, they're asking for cost factors. They're also asking for complete subpoena powers, because they're under a random subpoena authority to bring about the disciplines that we would try to understand from their perspective. I can sit here and I can listen to you all night long and you make a wonderful presentation, but I don't want to come back as combative. I want to come out across as having dialogue to understand your job and your position and my position as a citizen to that job. And it's at this point, it's very difficult.
No, I understand that. What
Okay.
I'm telling you is that my position, I am not the guy that can answer that question. I do not have termination power over any officer. All I can do is say, I believe a crime was committed. Chief, we need to investigate this. Or if it goes to the CP, the police oversight, they're not connected to my department at all. I don't know anything that's submitted to the police oversight. I have no investigative purpose with them. I don't assist them in any way with it. They are a separate entity. So it's 2 different groups you're asking about. I'm just telling you, and I'm not going to try to ever lie to you about anything. If I can't answer it, I will tell you, I do not have that disciplinary action. The worst I can do myself is give a letter of reprimand for something. Anything above that, days off to termination, is a commander, a major, or the chief.
Thank you.
So when you want to talk about that, you have to have the right person here to answer the question, because I can't speak for the department on termination offenses.
Thank you.
That's a different group.
Judge Cass, did you have something?
Oh, I was just going to say, I had really hoped that we had matured.
Somebody talking here.
I had hoped we'd matured beyond the concept of 0 tolerance, which is just another way of saying intolerance. Human beings need to be able to use discretion. That's one of the aspects of human beings. There are things that require consequences, but please, zero tolerance, I don't know who made up those two words and put them together, but I find it really offensive and dehumanizing.
I can tell you personally, I agree. I've never liked zero tolerance policies. I've never agreed with zero tolerance enforcement. You have to be able to look at the totality of the circumstance
Absolutely.
and decide what's the action I have to take now. As a police officer, we do discretion all the time. The classic traffic stops. I don't always issue a traffic ticket. I don't always stop a car speeding. Sometimes I turn on my lights, they slow down. I've had guys wave to me, thanks. You know, it depends on the situation, what's going on, and what else is happening out there. So I've never liked the zero tolerance idea. Some people believe in it. I'm just not one of them. If I'm ordered to do it, then I'll tell you what happens after that, because I've never been ordered to do that.
Okay,
And that's what-
I'm only using that terminology based on a neighbor that is not able to attend, that used that terminology. I agree with you, Ms. Bass. I've never used it in my policies in corporate either.
I will tell you that my experience, if a person does a termination offense, and they are found to have committed that offense, they will be fired. If that's zero tolerance,
Well, if that's zero tolerance to him, you know. he
if
can't-
that explains it, then yes. But that's how you can tell in a policy whether we believe something is so bad that it should be terminated. It'll have a sanction 1. Sometimes you'll see like 1 through 4, and that acknowledges that there are circumstances that normally we would fire somebody, but there might be some mitigating circumstances that doesn't deserve termination, but certainly deserves a suspension and the possibility of bringing them back into the fold so they can still be a police officer and still do the good job.
The severity of allegations, how high does that have to go before an officer is put on administrative leave?
I don't make that decision.
What? Is there anybody here that can answer that question?
You'd have to talk to the chief. If a person comes in drunk, I can relieve them of duty, but they're still put on admin by my boss the next day. It's a level above me that makes that decision. If I see something that they cannot work that night because of what they did, or that I believe rises to that level, that the potential's there, then as a lieutenant in the field, I can relieve them of duty for that night or that weekend, and then they get to see my boss first thing in the morning on a work day. I've had bosses come in on weekends and start the process to put them on admin, but it comes from a command level. And it's not a level that I could be told you were wrong. You were good to relieve them of duty, but it's not, we're not going to put them on admin. It doesn't fall at that level. Yes, sir. We'll go back to work and carry on with the rest of the administrative investigation.
Thanks.
I didn't say that wrong, did I?
I'm still curious about the difference in your description of what happened with Graham and the description in the court case. And I'm not saying that you're not telling the truth here, but it's just an interesting, different description, which paints a whole different picture. And it's a little bit like use of language. We paint different pictures and people hear and think differently about it. And the fact that he was passed out because of a diabetic seizure is a very different story. And that then he was handcuffed and shoved into the sidewalk is a very different story.
Without having read what's on there, I've read the case law. I tried to give you a summary in 1 minute of what Graham v. Connor was, so you had an idea about it. I've read the actual case and the Supreme Court opinion, the entire thing. He fought the officers and then passed out from his diabetic thing.
There's no description of any fighting.
I'm just telling you the case law that I read from it. That's what came out. But the part of it was to give you the idea of the situation and the officer's reaction, which led to this case law. If I wanted to give you a course on Graham v. Connor, one, I'm probably not the person to do that. You want one of our attorneys to come in because Graham v. Connor references 25, 30 other cases in their decision. So you need a lawyer to come in, actually a constitutional lawyer, to explain how this decision came about.
You need to know that there could be a million miles of difference between what comes out in a court-written opinion as to what the facts and circumstances were that the court took into account to reach its decision, and what the facts and circumstances that were in the evidence, and what the facts and circumstances were in the opinion and the stuff that was being read by whoever wrote whatever is there.
Yeah, we're actually looking at the facts that the court used.
So the
that's-
court recites the,
Yes.
Yes.
the court
Yes.
itself recites those facts.
Yeah,
Okay.
that is what we're looking
Good.
at.
Okay.
But, and I just want to point out that an important detail of this that may not have been clear from your description is that the Supreme Court in Grant v. Connor actually ruled against Graham.
Right.
The man who was handcuffed and with his, who was injured. And so the idea that this use of force policy was sort of further articulated or more limited through this case isn't necessarily the case. It's that objective reasonableness standard that was actually expanded. It sort of expanded the officer's rights in some ways because ultimately the court ruled in favor of the reasonableness of that officer.
The Supreme Court.
Yeah, the Supreme Court,
It
right.
did-
And so this is not a limit on an officer's rights. It was in some ways an expansion of the officer's rights.
And here's where, again, I'm not a lawyer, I'm just telling you how I learned this over in my study. It was a limiting and an expansion in some areas. It limited us to, we have to have this three-pronged test. But it did say, it added other stuff with the objectionable reasonableness, which was not covered in Tennessee v. Garner, which was not covered in the other cases before that. So we were limited down, and then in Graham v. Connor, they said, we can't go too far. You have to understand these criteria also. So they all tie together. But if you really want to understand the evolution of the law, you have to really read Tennessee v. Garner all the way through and Graham v. Connor all the way through to understand how this, because it was the same Supreme Court that made those two decisions.
Yeah, but who wrote the opinions?
Rehnquist,
Rehnquist wrote Graham v. Connor.
and I don't know about the other one.
I don't remember who wrote Tennessee v. Garner.
And that shouldn't make a difference, but it does.
Yeah, yeah,
It does.
yeah.
Tennessee v. Garner was Byron White.
Okay. Are there any more questions? We've got a couple more
I
questions.
have one. Paul asked about the CASA and how that's changed. And my question is, the other side. So, and you mentioned that one of your jobs is to review incidents, the critical incidents that could be use of force incidents, in order to learn from those incidents and improve policing. But it seems like, if you read the monitor's reports, that there's a pretty serious failure in APD in the initial investigations. Officers asking leading questions, justifying the use of force. Questions like, well, you were afraid, right? Yeah, I was afraid. Okay, that goes to the state of mind. That's essentially creating these things. So is there training that's being put into place to improve the kind of investigative component of how use of force cases or any cases are internally being investigated? Because you kept talking about the jury, but there's this big gap between, there seems to be a problem with that administrative investigation.
Without stepping on the chief, because he's probably the best person to answer that question, I can tell you what my experience has been. We understand that there's a difference between investigating a crime and an administrative investigation of the use of force. The way you question administratively versus criminally has to be different. We didn't think we were doing leading questions when we were covering the elements of the crime. So were you afraid of getting hurt? Most officers who watch interviews, no, I wasn't afraid, but I understand I could have been. That's critical in the investigation, that they understood that possibility of injury, therefore they had to use force. We didn't think we were leading, but we were doing criminal type investigations and questioning when we needed to learn how to do administrative. We are working on it. I think we have a ways to go before our, and again, this is my opinion, so if you really want to know the answer, you need the chief or chief huntsman to tell you, because they have the big picture. But I have been working on developing it for supervisors as part of our training program, incorporating more about how to do administrative investigations. We're trying to get the training that internal affairs officers get brought out to also being all supervisors. It is a slow process. It's probably the area that I'm least satisfied with as far as the development of the officers that work for me. And I wish I could step it up, but I think if I tried to speed up the process, I would actually hurt it, because it is such a massive undertaking to teach all supervisors how to do a thorough, proper administrative investigation, that I would rather take the time to teach them properly than teach them something wrong and then have to go fix that on top of it. So my answer to you would be, we understand it, we're getting better at it, but the formal training is still in development and still has a way to go before I would stand up in front of you and say, yes, we understand this really well. I have never been an internal affairs investigator. That is, they go through actual training on how to question like that. We're looking at sources to bring into our supervisor training, but nothing is formally online. We've done a lot of, here's checklists of the type of questions to answer, here's how to avoid leading questions, here's what your goal is of an administrative investigation. I think that's the baby step, first step of it, and we still have a ways to go before it's at a point where I would come in front of you and say, I believe we do a much better job. I think we're better at it, but we're still finding leading questions creeping into any officer that hasn't been an administrative investigator before they became a supervisor. The detectives are great at asking questions, but even them will be like, so what were you afraid was going to happen? Well, that question is leading in itself, but it wasn't the intent. You know, the intent was to answer the elements of the investigation. That's a criminal investigation, not administrative. Does that answer your question?
Yeah, I think so. I mean, I like the part where I appreciate you saying that there's room for improvement. I think that there just always is. And I think that building in, and I think one of the things that the CASA is trying to do, and I think that my interpretation of what the monitor is trying to do, is to change that. And I agree that, you know, the zero tolerance, that's ridiculous. We need to contextualize things, we need to understand them, we need to learn from them, and then we need to make every effort to not have them be repeated. And that's, you know, I mean, I think, at least for me, I'll speak for myself, I fully want an ABQ successful and a constitutionally viable police force. But I think you can't do that unless you really are self-critical and the supervisors really are, you know, holding line officers, field officers, you know, accountable, and they're holding themselves accountable.
I know when I came in, there was a question like the future of CPCs, and that came up with the Foothills one last week also. And I will tell you, I never considered the fact of them going away, because I don't see how we continue. If I ever walk in and say, we're good, case closed, then ask for my badge, because it's time for me to stop. I don't see the department ever being at a point where we finish a training cycle and then go, that's it, we're done, no need to improve. If we ever do that, we've got the wrong people in charge. You always go back to the beginning, because there's always now, you've got to analyze what's going on. Now what do we need to fix? There will always be something that can be improved. Technology changes, laws change, rules change. I just read some stuff about phone being used in a new way that can help police officers. That changes everything. So every time we make a step, we have to go back, do the analysis of what do we accomplish and what do we need to fix. Because there will always be something that needs fixing. So I was totally dumbfounded when I realized, like, wow, these things could go away if we're stupid. The police councils are an important part of the department. You're part of that analysis. And I'll give you the last example I do about this. We're looking at our field training officer program, the changes we need to make in the way we train recruit officers. I've been involved in developing that process for 14 years. I told them I have the wrong person to look at it now. I'm too locked in. You need somebody besides me being the person that looks at the data. Because people tell me, oh, this isn't working. I'm like, what do you mean it's not working? That's mine. Oh, that's arrogant. It's not mine, it's yours. I'm the guy monitoring it for you. So I have told them I have to step out. I cannot be involved in the next evolution. I'm too deep in it. I'm the wrong guy for this one. If we ever do that, and get to the point where we think we've got all the answers, then we're right back where we started from. There is good and bad that comes out of all this. I think the training from the CASA is great. We need to keep it going. I think the CPCs are a great resource for us. And if we ever stop cooperating with each other and sharing ideas, even if we disagree with each other, then we're doomed. Because that goes nowhere. I'm not always right. I hope that I'm willing to admit, if you point something out, that you're right, I was wrong about that.
I've always had the contention that, and I've told everybody this, the DOJ was brought here to fix Albuquerque Police Department. Now, I just heard in the more recent CPC, Chief Eden said it's our responsibility to fix APD. It was never the community's responsibility to fix APD. It was the DOJ. The DOJ said, adios. But my question is, if...
Yeah, because I can't respond to what the chief said. I wasn't there. I have no idea what he said.
Yeah, but I mean, that's just been the general contention out, you know, from all the CPCs. It's the community's responsibility to fix APD? No, it was the DOJ, and they said goodbye. But anyway, my question was before, what would happen if the government came and asked APD or the sheriff to assist in an ICE operation? What would your answer be? Would you participate in that operation?
I'm not the officer that would make that decision. That's the chief and the assistant chief's decision. If the decision is made by them to participate, then we'll do what we're told to do as long as it's legal. But it's the chief and the mayor's decision. That's not mine. So I can't tell you that we would participate or not, because I don't know.
Excuse me, we have time for one more question.
You really caught my curiosity, because I really got thrown. You were talking about administrative, and then you were talking about something else. Is there like two standards that I didn't catch?
No, the way you interview in a criminal investigation and an administrative investigation are two different interview processes, because they are guided by two different policies. Administrative has its own set of rules and guidelines that we have to follow to ensure due process under that route, and an investigative one for criminal is different. There are do's and don'ts for criminal that don't apply to administrative, and there are do's and don'ts for administrative that don't apply to criminal. I can tell you as a criminal that I know you committed a crime even if I don't. I can lie to you, and if you believe me and confess to a crime, perfectly legal. I can't lead you in an administrative investigation into giving me the answer that makes you look like you didn't do anything wrong. Two different processes. So you have to learn how to do your interviews and your questioning based on the type of investigation you're doing.
So you're telling me we have two different sets of laws?
Administrative and civil law, it's completely different. An administrative investigation is guided totally by civil law. Criminal investigations are guided by criminal law. And they are two completely different processes. That's why an officer could not be charged with a crime and still be fired, because it's two different guidelines. Criminal law involves probable cause and reasonable suspicion. Civil law is more likely than not. A completely different standard. So they have to be investigated under those standards.
Could you tell me what jurisdiction?
I'm sorry, we have to end the meeting. We have to adjourn, thank you.
Awesome.